exist and were of no legal effect. Secondly, we submit that when a court declares a law to be unconstitutional, that being a public law, such declaration binds the parties before the court, the public at large, and other courts of concurrent jurisdiction. Thirdly, the decisions and actions flowing from the impugned statute being in rem cannot be illegal or invalid retrospectively, and we will explain why that cannot be. Now, let me come to the reason we say that the effect of declaration of unconstitutionality of paragraph 5 and 7 of the second schedule to the IEBC Act in the Katiba case had effects other than those attributed to it by the Superior Court. First, the learned judges of the High Court, that is where the original scene was planted, the learned judges of the High Court, and I say that with respect, misconstrued the relevant provisions of the law in relation to the question of the petitioner's quorum to conduct its business. And I refer you, my lords, to the High Court's decision at paragraph 702, 714, 719 of that judgment. And you find this at page 7137 of the record. From a reading of the High Court judgment and that of the Court of Appeal, both courts seemed to proceed on the understanding that paragraph 5 and 7 of the second schedule of the IEBC Act were alive and available for use in the dispute before them. It is our very humble submission. Section 5 and Section 7 had been declared unconstitutional and were now dead and unavailable for any use. Now, let me take you, my lords, through the reasoning. In the Katiba case, which is petition number 548 of 2017, authority number 1 in our bundle of documents, the court found that paragraph 5 and 7 of the second schedule were unconstitutional. As at the time we appeared before the High Court, that decision had been in existence for 37 months. As at the time we appeared before the Court of Appeal, it had been in existence for 41 months. It was a valid judgment, a valid decision. There had been no appeal. And that order had not been varied or set aside. So the finding of unconstitutionality of paragraph 5 and paragraph 7 of the second schedule had never been disturbed. The result, therefore, my lords, is both the High Court and the Court of Appeal relied on a repealed law, a law that was no longer in existence. And it is our very humble submission that that was an incurable defect in law. We submit that the effect of a declaration of unconstitutionality is that the subject provision of statute ceases to have legal effect and cannot be relied upon. In the Katiba case, my lords, I would not waste your time by rehashing it here. The court did not elaborate what was to be the effect of its declaration of unconstitutionality. But in our submissions, we have said that this court has pronounced itself on this point many times. What are the various permutations where the court finds unconstitutionality? And I will not repeat that for the benefit of time. But it is our submission that in the Katiba case, there was only one interpretation that would be logical. The declaration was prospective into the future. It could not have been retrospective, because again this court has pronounced itself on the point, and that is to say that all acts rendered in good faith under the repealed law, under the impugned law, are sustained as legal if the finding of unconstitutionality is not retroactive. It is therefore our submission that that is a logical position that the court ought to continue to hold. Otherwise, the uncertainty of the law would bring chaos to the constitutional order. Let me revert to the case at hand. If paragraph 5 and 7 were no longer available, what then was the law on quorum? What then was the law on quorum? And we are saying there no longer was a specific law on quorum. And therefore, we would fall back to the provision of the Constitution on the constitutionality of the Commission itself. Let me give you a flavor very quickly of how challenging this issue was even to the Superior Court. The few judges who averted to it had very different views about what ought to happen. I draw your attention to the comments of the President of the Court of Appeal, Musinga J.A., at paragraph 359. His decision is at page 8306, volume 53 of our records. And he says, "It follows, therefore, where a court having declared a provision of a statute unconstitutional, but does not state the effective date of that declaration, the declaration becomes effective from the date of judgment, unless an appeal is preferred against the decision." We think that as a general proposition that is correct, except to add that even if an appeal is preferred and no order, no interim order is given, that becomes the ruling jurisprudence until the Superior Court has pronounced itself. To your JA, again at page 9145 of the record, which is volume 59, paragraph 125, says, "Where, however, a declaration by the court is silent as to when it shall take effect, the date of declaration is deemed to be the date of the effect." And that is the position we are urging this honorable court to take. The effective date becomes the date that that declaration was made. Now, there was, Tuyot J.A. made a very important observation that I would like to draw your attention to. And he says this: "An amendment of a statute is a legislative act, and while it is open to a court to declare an amendment to be unconstitutionally void, the declaration does not revive the former provisions." That is a very important point, my lords, and this is where the original error occurred. The High Court proceeded on the basis Section 5 and 7 were struck out. When they were struck out, the quorum provisions reverted to the status quo ante. This is our very humble submission. That cannot happen. And we are all familiar with the legislative process. When a bill to amend is presented to the House, it states paragraph this and this are deleted and substituted thereby by this one. Once the court finds that the deletion has created an unconstitutional, it cannot reinsert. Only a legislative act can reinsert. And that's what Tuyot JA is able to discern, and that is what would have assisted to. So, when then, now let me allude to the judgment of Cairo JA as well, because he helps us to capture this controversy. He stated this: the decision of the High Court in the Katiba case was silent on the effective date of declaration. Based on the decision of the Supreme Court, I take the view that the default position is that the declaration of unconstitutionality related back to when the unconstitutional provisions were enacted, with the result, in my respective view, that the status quo ante was restored. Therefore, the requirement of quorum was 5. And this is what we are saying with tremendous respect. This was the reasoning that took the court into error. And that the correct reasoning was the reasoning of Tuyot JA, that there was nothing to return to. Now, if there was nothing to return to, what should happen? Luckily for all of us, the Constitution at Article 250, sub-article 1, sets the minimum. It sets the minimum members you need in a commission, and there were 3. And IEBC at this point had 3. So it was not open to the court to find that IEBC was acting unconstitutionally. In fact, it was not open to the court to find that IEBC had no quorum, because to find that would have therefore to find that this institution did not comply with the Constitution, which wasn't true. The second point I want to argue, and I think I will be on my way, is that there existed a case in REM. There existed a case, the case of Biwott. I call it the Biwott case. Biwott versus IEBC. Biwott versus IEBC had made 2 critical findings. One, that the IEBC law contemplated vacancies in the commission, and 2, that the existence of a vacancy did not affect the constitutional functions of IEBC. Now, what do I want to submit about the Biwott case? Simply this: as long as the Biwott case existed, a decision in public law, in REM, it was not open to any other court in the High Court, a court of concurrent jurisdiction, to come to any other finding, or rather to purport to overrule that particular issue. In our view, we submit that a declaration by a superior court on an issue in REM alters the subject matter of the declaration. Remember this: from when the Biwott case was determined, every public official having anything to do with elections was now operating on the basis that this was the law. And my lords, let me remind you of another instance where I have appeared before you with the same problem. You will recall the 2017 presidential election. And you will recall there was the minor KI decision where the Court of Appeal, in its wisdom, had changed the jurisprudence of voting. And IEBC had changed all its procedures to obey the minor KI decision. Then when we came before you, questions arose whether the minor KI decision was actually sound law. But this court came to the conclusion that to the extent that there has to be consistent in jurisprudence, public officials who act on the basis of the law as pronounced by the court cannot thereafter be blamed for such action. The Biwott case remained the jurisprudence available to guide IEBC. It was a judgment in rem on a public law issue, and therefore the High Court, and I want to make this other slight point, sometimes we lay some premium on what we call the 3-court bench, the 5-court bench. In our jurisprudence, that is about numbers. It has absolutely no juridical value. The judgment of a single judge interpreting the Constitution has the same juridical value as the judgment of 5 judges. That is our submission. And therefore, the way the High Court dismissed and swept away the Biwott case was unprecedented in our jurisprudence and was wrong. And it is therefore our submission that this court be persuaded to the position that the court acted in error. We have referred you, my lords, to the Canadian case of the Supreme Court of Canada, to the English case of Ems versus Queen, and I don't want to go through them because they will just take time. So, what then is my final submission before I call my learned colleague? IEBC was always properly constituted. It had the quorum mandated by the Constitution itself. And there can be no higher law than the Constitution itself. The High Court and the Court of Appeal were in error. The High Court and the Court of Appeal were in error in arriving at a contrary position, and the High Court and the Court of Appeal were in error in disregarding the effect of an existing judgment in rem in a matter of public law. I thank you, and I call my friend Mr. Eric Gumbo.